we received good cooperation from the SABC board and the officials who were relevant during the investigation. As we indicated when we started, we adopted a phased approach, phase 1 and phase 2. This presentation summarizes the outcomes of the investigation into phase 1, and will also provide an update on the status of all phase 2 matters covered by Proclamation R29 of 2017. We'll also present on the additional proclamation that I referred to on the security tender. If we go straight into those matters that were investigated in phase 1, as I indicated, that some of these matters that we investigated, they also emanated and were identified during the ad hoc committee inquiry, and all of those contracts that are mentioned on the slide number 7, we did find evidence that indicated that there were irregularities in the awarding of these contracts. It's Vision View Productions, Sikela Kabiso, Lona Vision, Laser Consulting Economics, Trading as Infonomics, Asanta Sana, and Foxton Communication, and Mott McDonald. We do summarize what each contract was contracted for in the next slides. We also obtained evidence that indicated that there were irregularities in the awarding of what was called success fees to the then Chief Operating Officer, which is Mr. Motswening. We also investigated some of the appointments and salary increases that were effected during his time, and we found that there were irregularities. We'll take the committee through that. There were some of the findings that were made by the public protector. We also found evidence really supporting that some of those findings relating to staff increases or staff appointments were irregular, and there are names that are indicated on some of them, and we will indicate later on what their positions were. In some of the instances, we really found that there were no irregularities, and that the appointments were done in accordance with the policy. Slide number 9. As a result of the investigations conducted by SIU, we, based on the findings, we then prepared court-ready evidence, and in respect of some of the matters, and there's about 45 matters as per the outcomes in the investigations. Just to indicate to the Honorable Committee that most of the outcomes, as we investigate, if we find that the contracts were awarded irregular, it is our duty by law to institute civil proceedings, and with the aim to recover what the corporation may have lost. And we then set the contract aside, obviously through the high courts at the moment. Once the contract is set aside, we also request the court to order a just and equitable outcome, which would see some of the monies recovered. There's also referrals to the NPA, and these referrals come as follows. If during the investigation we find evidence that points to criminal acts, we are required by law to take that evidence to the National Prosecuting Authority for prosecution. There's also outcomes that refers to the disciplinary process. When we investigate, if we pick up that any of the officials of the corporation are guilty of misconduct, we then refer those matters to the accounting authority, in this case the board, but we also notify the executive about the matters. And we then work closely with the corporation to ensure that there's execution in those matters. There's about 10 civil litigation matters instituted. In some, in fact, most of those matters, the SABC would have already initiated the process, and we would then request the court for SIU to join the proceedings, and we'll indicate in all of those. There's about 11 criminal referrals and 24 disciplinary referrals. In all of these referrals, as I indicated, we work closely with the corporation to make sure that there's execution. We have implemented some measures to ensure that we follow up on this and make sure that we enable the execution of these outcomes. On the civil litigation side, because we have realized that we experience a delay in the ordinary courts, there's a process that was initiated so that the special tribunal can be re-established. And that tribunal is in the process of being established through the Department of Justice. We are at the stage where the rules and regulations of the special tribunal just needs to be signed off, and the minister will sign them off. Once that is done, the tribunal will then be up and running. So what we will do once the tribunal is established and functional, we will then engage with some of the parties in the litigation process so that we can take some of these matters to the special tribunal. That is a legal process that we will engage in. On the prosecutions, we are engaging on an ongoing basis with the NPA to ensure that there's priority given to most of these cases, including the SABC cases. On the disciplinary matters, we also, as I said, we support the corporation and we make sure that there's appropriate follow-up. Where there's support in terms of evidence or witnesses, we ensure that we provide that support. The investigation has produced evidence to initiate or join civil litigation instituted in the name of SIU and SABC in the High Court, and these are about 10 matters. The value of the litigation matters, and the value is derived from the contract value, is just over 560 million. And as I indicated, that all of these contracts, we have evidence that indicates that they have been irregularly entered into. So our view is to seek to set this contract aside and then seek to have a recovery of all those monies that the corporation may have lost, subject obviously to the legal process and the orders that the courts will make based on the evidence that we would have presented. There's one matter where we provided evidence for the matter of Asante Sana. We'll come back to that. The claim of that matter is about 350,000. The next slide deals with what we referred as the success fees. These success fees, our evidence reveals that these would have been the fees paid based on some of the official work that Mr. Motswening would have done in, call it, negotiate or arranging the contract with MultiChoice. So, in our view, is that those success fees have been paid irregularly to Mr. Motswening, and there's evidence that we are ready to present to court based on that. So we and SIU and SABC have jointly issued summons on the 5th of February 2018 in the High Court of South Africa, Gauteng Local Division, against Mr. Motswening. The civil case consists of two claims, as I indicated. Firstly is the so-called success fees, and the second part is the part relating to the prejudice, pecuniary prejudice that the corporation may have suffered as a result of the irregular appointments and the irregular increments and suspensions and unlawful terminations of employment. We've quantified the claim to just over 10 million, and that forms part of the litigation process. The papers have been served, and as we indicate lower down on the slide, the civil process is underway. There's a case number provided, and Mr. Mutwening is defending the matter. So we have until the 20th of September, which is the day before, day after tomorrow, to file some of the court documents. We've got our chief legal counsel here. If need be, can add on, but this is an ongoing civil litigation. Unfortunately, we have to abide by the court processes. But what we are doing, Honorable Chair and Honorable Members, because we understand that the quicker the matters are resolved, the good for everyone, particularly for the corporation that needs this money direly. We have engaged with the judges' presidents across the high courts to assist with what they call case management. So they institute that case management in a manner that seeks to avoid unnecessary delays, either on the part of the applicants or on the part of the respondents. So once the matter goes to court, they would have then case managed it such that any of the legal impediments are dealt with upfront. So, and we are seeing results of the engagement, such that some of the matters are enrolled. We've got some of the court dates already. So even before the special tribunal is in place, we do engage to seek speedy resolution of these matters. The one agreement that we now talk to is the one relating to audit services. We have engaged into the civil litigation together with SABC against Sikala Kabiso to review the contract and set it aside. This contract was entered to on the 3rd of October 2016. The value thereof is about just 9.8 million. And we, as SIU, successfully joined the litigation. As we indicate there, the notice of motion was issued and the process went on. This case has already been heard. So the review application was dismissed on the 14th of June, but we have filed for leave to appeal and on this matter, because we believe that there's a prospect of success on appeal. So we are waiting a court date on that matter. In respect of other contracts relating to this company, evidence that we obtained indicated that the deviations that were made did not meet the requirements of the SABC supply chain management and also of the PFMA and the requirements of the Constitution. In that regard, we make appropriate findings. The next contract that I refer to is the contract relating to the company called Vision View. That contract was to build a multi-purpose studio. We obtained evidence, again, that indicated that this contract was irregularly procured. And as a result, we got into a civil process to get it set aside. The monies that were paid up to the date of the institution of the litigation was about 34.4 million. The total contract amount is 52 million. Again, this matter has already been heard. So we are seeing, based on the engagements with the High Court's judge presidents, that they, one way or another, are able to assist the process. The matter was heard, and on the 9th of November, we were successful in the judgment, and it was handed down by the High Court, setting the contract aside. However, the court made a ruling which we do not agree with. The contract was set aside, but when it came to the just and equitable, which is really where we would like the recoveries to be ordered, the court ordered that aspect to be referred to an arbitration in terms of the agreement between the two parties. So we are saying, if the agreement has been set aside, we cannot have some of the aspects that are still applicable. So that's really the basis, and we will argue that in court. So we have taken that aspect on appeal so that it doesn't set a precedent which is not going to help us going forward. And the company has filed an application. We are informed they seek to introduce new evidence, and that is subject to a legal process. So we are anticipating that that process will also be concluded appropriately. The next slide, we've also instituted the civil litigation against the former SABC executive, James Aguma, and Lorna Vision. This contract was entered into for purposes of collection of TV licenses. In this regard, the SIU submitted evidence to the SABC attorneys in support of the civil claim to recover an amount of 62.7 million. We issued summonses against both parties, and the SIU has been given leave to join the proceedings. Again, there's legal process that's going on. There's amendments that were due, subject to that legal process, and the deadline for those amendments to be filed is today. So our chief legal and the legal of the corporation will have to ensure that we meet the deadline. We will explore, as I indicated, avenues to expedite these matters by engaging with the judge's president so that the matters are expedited. The next slide deals with the matter of fruitless and wasteful expenditure against, again, a former official of SABC. The name is Bessie Tugwane. Our records show that she was the acting COO. We are claiming for liability for fruitless and wasteful expenditure incurred cost in the award of the Vision View contract. That is the one mentioned in slide number 13. Summonses have been issued against this. There's two officials, and we'll indicate later on what happened to Mr. Padeachi. We are reported at the time of finding out that he is out of the country, and we are monitoring the situation once he gets back into the country. We're saying it at the end of that slide. There's legal process that's going on, and we will also ensure that this matter is also expedited. I'm informed that the value of this claim is about 42.3 million. Again, on the same basis, we'll seek to expedite this matter. The next slide deals with the one on economics. This contract, our evidence reveals that it was awarded for the commercialization of SABC digital strategy. We also found evidence that indicated that there was an upfront payment, which we are of the view that it was not due. We applied to court to declare the contract invalid and claim the damages suffered by SABC. Again, as I indicated, that the court process is underway. The company is opposing the matter. We will indicate the value of the matter is about 4.5 million. So we are informed, although the case has been now scheduled on the roll, honorable committee members and chair, the date that we were given is 14 May 2020. So for us, that's the part that we really cannot control because it's based on the court roll. But we are of the view that once we have our own tribunal for these matters, that will alleviate. There's also a civil matter that we have instituted against the then acting Chief Finance Officer. The name is Audrey Rapela. The claim against is for the unlawful authorization and approval of Mr. Mutwening's personal legal fees, as well as the upfront payment in terms of the appointment of the Infonomics company. I'm informed now that the value of that matter is just over 20 million. So in this regard, we sought, as we always do, that we think every time of new ways of doing things. We realized that where there's a possibility of recovery against, I would say against anyone, but in particular, if it's against the officials, who choose to leave the organization in the face of consequence management. We also considered the issue of laying a claim on the pensions. And this is one of those cases where we sought to say it almost works similar. The principle is the same as the asset forfeiture unit principles. Because in the asset forfeiture unit process, you would seek to freeze the assets even before the matters are heard. And then when the process is concluded, you would then, based on the court order, will then forfeit. So in this regard, as I say, the principle is similar. We thought it would appropriate and prudent to freeze the pension just so that there is an opportunity to recover. So once the pension is freezed, the legal process will take its course, and once it's concluded and there is a court order, we can then lay claim to recover the monies to the corporation. And we will seek to do this in any appropriate instance, any appropriate case that we deal with. In this case, I'm informed that based on the legal process, the documents have been exchanged between the parties. There was a pre-trial conference that was scheduled to take place the day before yesterday. So I'll seek to find out from our legal team what transpired. Hopefully, it transpired well so that the matter can progress to hearing. The next slide is the recovery against a company called Mott McDonald. The SABC, in this regard, our evidence reveals that they unlawfully procured the services of this company to revamp the lifts. And the value of this matter is about just over 7 million. As I said, in many of these cases, the corporation would, out of its own accord, have initiated processes to set this contract aside. In this case, the SABC brought an application to declare the contract invalid. We also brought a joinder to join. So this matter has, again, been enrolled. We're really seeing traction from the court processes in enrolling these matters. The matter has been enrolled on the unopposed roll for the 21st of October 2019. And we are expecting a positive outcome. Honorable members and honorable chair, that sees a conclusion on the presentation on some of the civil litigation matters. And what we have realized is that the investigation on those matters has been completed, and we have referred evidence to court. We are instituting action to recover on behalf of the corporation, jointly with the corporation. Where there were officials who were guilty of misconduct or any other infraction of the law, we have referred those matters to the appropriate authorities, be it NPA or if there's a need to discipline these officials. So we are seeing traction in terms of holding people, though, or officials, and those private companies. We're holding them accountable for the irregularities that may have been committed. We are now entering into that aspect of the referrals based on the criminal evidence. In terms of our law, when we investigate and find that there is a criminal action that has been committed, we are required to refer that evidence to the NPA. And our legislation says once the matter has been referred to NPA, it has to be dealt with in the manner that serves the public interest. So we've engaged with the NPA. The common understanding, and even out there in the public's expectation, is that once matters have been referred, they should be acted upon. We have engaged with the NPA. We are seeking to find out what the decision is. That decision should either be to prosecute or not to prosecute, but what we are looking for is a decision, one way or another. If it's a decision to prosecute, indeed, that is really first and foremost what we would like. If it's a decision not to prosecute, we will also sit down and understand what were the shortcomings based on the evidence that we have collected. But of all those referrals, we've referred about 11 matters to the National Prosecuting Authority. To date, there's one matter that was enrolled as speedily as we wanted to see. There's one matter relating to one executive, and that matter relates to the fraud, and the slide number 19 deals with that matter. This person made herself guilty of fraud relating to the bursary scheme of the corporation. So we will give an update on where the matter is later on. In respect of other 10 matters, these matters involve criminal referrals on the companies who contracted with SABC and some of the directors and of eight former SABC executives, and including some of the directors whom evidence pointed out that there's been unlawfulness. We also quantified the values around these criminal matters. Because in terms of the Criminal Procedure Act, there is a process at the end of every matter where the court could also rule that the accused person pay back the monies that has been lost either due to fraud or any other criminal action. So we are seeking to see that that clause in the Criminal Procedure Act is also invoked in the process. We are glad, though, have been informed by the NPA that they have provided a dedicated prosecutor to deal with the SABC prosecutions. This is based on our engagements with the NPA to ensure that there is traction and these matters are attended to. We are hoping to see positive action out of that. Slide number 20 deals with MPA referrals still relating to the success fees paid to Mr. Musoni. The evidence pointing towards criminal offence committed in respect of the payments of the success fee, there's against 2 SABC officials, 1 current officials and 2 board members, former board members, have been referred to NPA. Yes.
I don't mean to interrupt. I think for consistency, because we've been naming everybody this far, let's continue on that trajectory. So the names of those in the meantime, of the one official and the 2 board members, because I think we've been naming people as we go. So
indeed. Yeah. Chair, may I just indicate that in cases where we have put names on the record or on the presentation, is those instances where action has been taken or criminally they've been charged. In cases where they've not been charged or the matters, in all of these civil cases, the court papers have been issued, so they are public. So we're able to mention. So in some of this, in the one criminal matter that we are mentioning, it's because the accused has been charged. So the matter is in court and is public. So in some of these matters that are not yet in court and not yet public, we would really plead with the committee that to guard against the legal risk that we may incur, that these individuals really not be mentioned. The investigation has also produced evidence in support of about 24 disciplinary referrals out of the investigation. We're giving update on where what happened to all these referrals. The impact of these referrals has been that there's a few executives or an official that have exited the corporation. 2 have been found guilty of disciplinary charges, 1 dismissed and 1 resigned. 2 resigned in the face of disciplinary, and the other 1 contract expired and not renewed. Then we also just mentioned to the Honourable Committee that where officials resign in the face of any action that's taken against them, the only relationship that resignation terminates is the employment relationship. Because of that termination of employment relationship, the corporation cannot take an action as an employer. There's no employer-employee relationship anymore. But where evidence points that the individual could be followed on a civil process, though the resignation does not help them with that. The resignation also does not help them with criminal prosecution. So we will then still follow them on that basis. The next few slides really deals with.
Sorry, Mr. Chairman, just if I may interrupt here. Here we've got a case where people have been disciplined and so on. So here names could be given to us.
Yeah, I'm sure. On slide 21, the investigation has produced evidence to support the following 24 disciplinary referrals. And then it goes on to say the evidence implicates 14 officials whom have all been charged, involving seven SABC executives and 8 SABC officials.
Thank you, Chair, for that. There's an opportunity in the following slides where we're naming the officials and what outcome has been. If we go straight to slide number 22.
Fine, colleague, with that. All right, thank you. You can continue.
There's an official called Kubendran Padayachi. This person was the acting group executive. His actions or the disciplinary process related to his conduct relating to the Vision View contract. And we were informed that he resigned in the face of the disciplinary process. There's a case of Suli Mutweni, that's the part, she's also been charged criminally. She was the group executive of sport. She's been dismissed. The former acting chief operating officer, based in Ghana, her contract expired and was not renewed. Simon, or her action related to Vision View, Simon Mulaudzi, who was the head of procurement. His action related to all those three: contract, vision, view, Sekela Gabiso, and economics. He's been dismissed. The former acting chief financial officer, Audrey Rapela, also the information we got is resigned in the face of disciplinary action. This is the instance where we have managed to freeze the pension fund, and the freezing was done legally through the court process. There's another official, Anand Mutlia. This was the group secretary. He was found guilty, but we are informed that a final rating warning was issued. Sifiwa Mulaudzi related the action relating to economics. She was the group executive of commercial enterprises. She was found guilty, and again in this instance, we are informed that she was given a final written warning. But we are informed that she's currently on suspension as a result of other SABC internal process. So some consequence management is still continuing, despite. There's a person who was the general manager of supply chain management, governance, and special projects, Ayanda Mkize, action related to economics. She's been dismissed since. So Chair, we're really seeing traction in terms of what we call consequence management. So this is the trend that we would like to see, and we are engaging with the accounting authority, being the board, just so that we are kept informed about how our referrals are being acted on. The next slide relates to the criminal case that we instituted against Suli Mtsweni. As I indicated, this is one of the matters really that were taken through to court as speedily as we wanted to see. However, the status of this case is that, towards the bottom of the slide, the criminal trial commenced on the 4th of September 2019 and was postponed to 30 January 2020. So we continue to monitor the process just so that there's appropriate outcome. The recovery of the amount that was lost, it's about 45,000, will be dealt with as part of the criminal proceedings. So the next slide deals with one of the areas that we needed to investigate, was the multi-choice. Slide number 27. The investigation revealed that certain provisions of the contract have been unlawful by virtue of being in contravention of the government's prevailing. We are informed that it is actually referred to as the Broadcasting Digital Migration Policy at the time, as well as against certain provisions of the Broadcasting Act. When we investigate, we found that the contract has already expired. So to take the process forward and take it to court would be futile. But however, there's evidence also that indicates that the signatories to that agreement were, as at the date of the signing of the agreement, not duly authorized to sign it, and that a false or incorrect resolution had been compiled in this regard. In this regard, appropriate action will be taken. This aspect of the investigation is still underway. Appropriate action will be referred based on the findings. Either it's against the executives or the accounting authority members who were in place at the time. we're also of the view that in respect of the financial viability of the expired agreement, the evidence obtained indicated that it was financially viable at the stage of entering into the contract. This is probably from a business perspective. However, there were some losses that the corporation suffered in this regard, and that aspect is also still under investigation. There's reference to a new contract that the corporation entered into, although it was really not part of the scope, but we looked at it to check whether there is a base to either amend the proclamation to include it, but we didn't find that there's evidence that necessitated that. That concludes our presentation on phase 1. We now enter into the phase 2. And I go straight to slide number 31, which indicates some of the focus areas of the investigation. The investigation covers TNA. It also, because this contract was scoped for the second phase, but again, based on the agency that I indicated earlier on, we covered the security contract, and based on the amendments.
We also would refer to the new age.
Sorry?
TNA would
yes.
New age.
Yes.
Right.
Oh, thank you for that, Honorable Chair. It's the new age indeed. We also investigate irregular appointments of officials, irregular payment of bonuses to senior managers. There's some payments which allegedly, the allegations we received that were paid irregularly. Some irregular expenditure relating to tax matters. There's a SARS penalty, which if due care was taken, that penalty would probably not have been incurred. The investigation will look at that. Some clearance, tax clearance certificate, validity issues that we need to look at that, and then we'll also look at the conflict of interest of the corporation officials. There's further allegations on page 32 related to some payments to the 53 artists about the Legend contract concert, SABC Heritage or SABC Thank You concert to the tune of 27 million. There's also a Rapid Blue X Factor Season 1 irregularities regarding the lease of some office in Nelspruit, irregular payment of Mr. Mutwening's legal fees of about 1.2 million. There's also various allegations that we have received relating to Northwest SABC offices. Those related to the appointment of the general manager, provincial news editor, officials doing business with the SABC. This relates to the conflicts of interest. We're also investigating possible corruption and abuse of SABC resources. The next slide, slide number 33. With regard to TNA, when we commenced with the investigation, again, the SABC board had already taken some steps on this matter. And those steps resulted in the contract being cancelled. But however, we were informed that TNA was taking legal steps to recover from the corporation to the value of about 144 million. So we also entered the fray in terms of assisting the corporation, and we give some details in the next slides. The security contract, as I indicated, we've already finalized it, but we talk briefly to it later on. This new age breakfast, as we said, the investigation is ongoing in this matter. However, the facts and circumstances pertaining to this contract having been skewed deliberately in favor of TNA, those aspects will be investigated, in that it deprived SABC of the revenue that was being made from all of this. breakfasts that were held. And we are of that view simply because there were some sponsorships that were paid, and those sponsorships, our preliminary finding is that they were paid by some government departments and state-owned entities. So what we will do, because they're not really covered by the proclamation, the last bullet point on slide 34 is that we are considering to apply for a proclamation to investigate all of these sponsorships. However, we have been contacted by the State Capture Commission on this aspect. But the nature of the discussion is such that they would like to understand what is it that we are focusing at, what is it that they are focusing at, just so that at all possible there's an avoidance of duplication. We were scheduled to appear at the State Capture Commission. However, the chairperson of the commission indicated that it's not prudent at that time for us to appear, but we continue to engage with the investigating team at the commission. Slide number 35 really just goes into some of the observations that we have to date. That the contract entitled TNA to sponsorships, in our view, those were exorbitant amounts paid by state departments. Those enabled these breakfast shows, and the revenues, all of them accrued to the TNA. As we indicated, they instituted arbitration against the corporation, which we joined to then defend the corporation. And with a view to defend this, the SABC brought an application to have the contract reviewed and set aside. We also joined in that matter. However, there's an issue that really presents some legal questions in terms of what would happen to the TNA. Are we not likely to come back with a hollow order from court simply because there's liquidation processes? In this regard, our chief legal counsel indicates to me that that is not an impediment. We will proceed with the litigation process, even beyond the liquidation, if there's assets that we can lay our hands on based on the legal framework that's applicable. As you can see there, that there's a liquidator who has been appointed, so there's dealings with that liquidator to ensure that the interests of the corporation are also taken into account during this liquidation process. The security contract, slide number 36. Again, I need to underscore that this matter is also in court. There's litigation pending. We have joined that litigation, but I suffice to say we have found that the contract was irregularly awarded, and also we found that there were financial misconduct on the part of the officials and some of the members of the accounting authority, which are the former directors, and we have referred those to appropriate institutions, including the NPA. We have briefed our counsel to join the process. We will obviously seek to have this contract set aside. The proceedings were already underway, having brought by the company that did not get the contract. However, we are in their prayers. They are of the view that they should be awarded the contract. Well and good, that is their right to pray like that to the court. But we are of the view that the contract is irregular. If the court declares so, this is not our view that it should just be given to the other company. This process must be done properly. must be started afresh. In this security contract, we've already submitted the reports to the president, and the presidential report has been made available to the corporation. It was also required as part of the court process. In all of these processes, Honorable Chair, members, we look at the responsibility of everyone involved, and in particular, the role of the accounting authority, which is the board, in instances where we find that there's irregularities and that the board had not executed its function in accordance with the applicable law, we make that finding and make the appropriate referral. So this slide essentially indicates that in all of the investigations that we have conducted, depending which accounting authority was in place, if there's a point that any of the irregularities points to a certain accounting authority, we'll make finding relating to that accounting authority. So as we conclude the investigation, we are also going to have a focused investigation around the governance space. And this would indicate to us what the governance framework was or is, and if there's any governance inefficiencies, how is it that they could be remedied or how they could be improved. That aspect of the investigation is underway, and we'll conclude it well before the final report, and we will engage with the accounting authority based on that. The last slide, Chairperson, really it's a summary of the outcomes that we have presented. In summary, on the left-hand side is the civil litigation instituted. In 10 matters valued to about 560 million. Contracts that were set aside successfully, valued at about 114 million. The next block refers to the NPA referrals. We've referred about 11, and there's one asset forfeiture unit referral. The next block is about the evidence on misconduct. We've referred all the cases to the accounting officer or accounting authority. The next block relates to our interaction with other regulatory authorities. It could either be SARS or Institute of Directors or any other authority that we need to engage with based on our findings. We have already submitted an interim report based on the overall investigation that was submitted on the 21st of September 2018. And on the security contract, we acted on it. We have completed the investigation, and the final report was submitted. Honorable members and Honorable Chair, that is the end of our presentation. Thank you very much.
All right. Thank you very much to SIU. I think that for the purposes of getting the global picture, let us hand over to the chairperson of the board, Ms. Makatini, and we welcome in the CEO and the team who are here, and then we will then take questions. Honorable Deputy Minister, welcome. Mr. Chairperson.
Thank you, Honorable Chair. Greetings, Honorable members, Deputy Minister, SABC Board, and the executive team. Receive my greetings. We appreciate the opportunity and the presentation by SIU. We're working very close with the SIU. A lot of the matters they've investigated were initiated by the SABC, so their presentation covers quite a lot of what we are doing. But I do want to give honorable members and the chair a comprehensive picture of how we are driving consequence management and what are the things that informs the work that we are doing in the area of consequence management. And the main goal there is to recover monies that were stolen, and also to make sure that we restore governance And in doing that, we're basically dealing with all legacy and governance issues. There's quite a number of input that is helping us with those efforts. One is the Public Protector's Report of 2014. So that report highlighted a number of things that needed our attention. And the remedial action coming out of the Public Protector's Report are binding on our side. So it's not optional. We have to implement those. The second report that is also informing the activities around consequence management is the ad hoc committee report, which was the exercise done by Parliament. The third one talks to the Auditor General findings. So Auditor General will come and audit and highlight a number of things or lapses that needs to be attended to. That's a third input that is informing consequence management. SIU, of course, the presentation that you've just been taken through is a fourth input to that. But the last one, which is also very important, is our own internal forensic. In the last financial year, the internal forensic team worked or produced about 180 forensic reports. So I'm giving you that so that you can have a comprehensive picture that we're not only limited to what SIU has investigated, but there's a whole lot of other input that is helping us drive the issues of consequence management. And you may have seen, honorable members, in the media, negative news about the SABC, and I just want to put that into context, that as you follow through and try to hold people accountable, as you dismiss people, suspend people, or investigate for what they've done wrong, they will fight back, and they are fighting back. You may have seen round about June that our chief audit executive was almost killed in an attempt which we strongly believe is as a result of the work that we are doing. So in terms of the key executives that are in the forefront of fighting corruption, driving renewal and rehabilitation of the SABC, their lives are under threat because there is a very strong fight back. And they're working with some of the media people to undermine the work that we are doing. But we are committed, and the executives are committed to do what serves the best interest of the corporation. In all that we're doing, I do also want to make sure that honorable members are comfortable that processes, procedures, and our own policies are being followed. So when we hold people to account, when we discipline people, we are making sure that when we're doing that, we observe and adhere to our own HR policies. So nothing is being done outside of that policy. But of course, there will be noise out there because if people have been just enjoying, eating, stealing without anybody holding them to account, they will try to fight back. So ensuring sound governance framework and instilling sound internal control is part of our key strategy, key pillar of our strategy. So this has become part of the new turnaround strategy for the SABC to make sure that we ensure that there is sound governance. And it is part of our continued effort and commitment to deal with the systematic collapse of governance in the SABC financials and to basically deal with all the issues of corruption that have engulfed the SABC. It also affirmed the SABC's board commitment in consequence management. We have to hold people to account. It is the right thing to do. But also, there are those of our employees who've done their work with diligence, with integrity. And when they see no action being taken against those who have been found to be implicated on wrongdoings, they are expecting us to take action and to make sure that we do what is necessary. So we are dealing with, intending to deal with all the cases that the SIU has investigated. So everything that the SIU has presented, we are working on those and we are addressing those issues. So a lot of these things are historic matters, but it is important for us to deal with those legacy and governance issues, but make sure that we put systems in place to ensure that there is no reoccurrence of some of these issues that SABC has been faced with. So that would be my opening remarks, and I'm going to request Advocate Vanara just to give you some input, and then you will be followed by the HR executive, so that we can fill you in terms of the other cases that we are dealing with and give you more details, so as to make sure that you have a comprehensive picture coming out of what the SIU has presented.
All right, no, that is fine. Mr. Chair, is he speaking to this presentation here? Or is that another presentation? The only one I have is this one.
Thanks, Chair. The idea was really to speak to that presentation. But as you would have read through the presentation, as well as the presentation given by the SIU, it is a carbon copy because we're doing the same thing. What I would like to do, though, is perhaps piggyback on the SIU presentation, but highlight some slight variances insofar as it is applicable to the
Are you
SIU.
presenting another presentation or not? Like, do you have anything? So I want to make sure that members are following. So is there a presentation on what of the piggyback?
It is the same SIU presentation, Chair, but I'm going to refer to the relevant, I'm not going to go through the same presentation, but there are certain areas that I'm just going to highlight, where there's slight variance.
All right, it's fine. No, let's do that. It's just that one would have hoped that that presentation would have been circulated because it makes it easy to follow. Because as you say, your presentation that we have received is a carbon copy of the SIU. So now if there's annexures or additions, it would have been preferable that they would have been circulated. It makes it easier for members to prepare as opposed to receiving things raw. So I think but it's fine. Carry on, members will. If you just need to stop the advocate on the way, just do so that it can clarify the issues. But I think it will be helpful in future. All right, let's carry on. Over to you.
Point taken, Chair. On the SIU presentation, Chair, if we can just go to page 8. Page 8. Yeah, that's the one. The last sentence there that says the SIU found no evidence to support allegations of irregularity regarding the appointments of other officials. 2 weeks ago, Chair, we had a meeting together with the SIU because in our view there were certain officials that the investigation reports had indicated that they were not irregularly appointed. We had a discussion around this issue because in our view, some of those officials were irregularly appointed and that they were part...
Sorry, Chair, to interrupt. Chair. You see, Chair, the SIU has presented a report. The advocate is coming now and presenting another report and then picking out things out of that report and say, no, it's not entirely correct. We had a meeting with the SIU 2 weeks ago. That is not for, that kind of discussion is not for us here. They should go and meet with the SIU, discuss those things, clear up and present one report to us. It's very uncomfortable that they're coming and now picking on the report certain things that is not correct. Those should tidy up those reports, meet with the SIU and then present to us. We don't want that kind of thing. They should now go to the report and say, no, this here was not like that. We had a meeting, we changed it. Go sort your business out and then bring it to us. Because now we don't want to go through that now. Then we'll start getting involved in that discussion too now about what is correct, what's not correct.
All right, Honorable Solomon and Honorable Hadel will then each, and then we'll just tie it down on this one.
Thanks, Chair. I think it's in order that indeed SIU made investigations either on behalf of the State General or on matters that matter for public good. In such an instance, engagement with an authority has taken place. Of course, there might be issues that they won't be happy with, but it's not within our purview to deal with such, as we have in front of us the report of the SIU. And we sought to follow that trend as an authority which does the investigations. Because we run a risk here that there might be some matters that are indicative, pointing a finger to the board. And they would come in this instance to punch holes within those matters, and it won't be assisting us in terms of having to delve on such areas. One example, which I'll be interested in, if we would move towards that angle, I will come later on in terms of such indications. Thank you very much, sir.
Honorable Hatter with an H, and then I'll tie down on this one.
No, thanks. No, I'm covered, Chair, because my interest on the exact same matter was to get an understanding of how many are those cases, not to open another investigation, whether or not there are issues outstanding, and also to get an indication that now these cases are done and dusted. You have satisfied yourself with the investigation.
No, I say, that's why I asked the issue, is there another presentation? And I deliberately allowed us being referred to a page because I wanted to see where we were going. I don't think it will be proper that the SABC now wants to respond or react to the SIU presentation. I don't think it's for the SABC to do that, nor is it for us at this platform. Where there are areas which are a work in progress, rather we indicate those. Should a question about it arise, say no, this is a work in progress. But when we now start having a dialogue, because then the SIU will rightly say, right, Chair, we want to respond to that. And then now we sit here and watch towing and froing. The SABC, if it has a presentation, it must present its presentation. That opportunity is available. And then we will take it from there. But let's not walk down that road of. I think the introductory remarks of the chairperson of the board were sufficient to speak about cooperation and the action steps that they have taken and the issues that he is raising about consequence management, which is in order. The presentation by the SIU is to the committee, not to the SABC. So Advocate, I would request that you rather, I think, speak to your matters where there are discrepancies with your, that for us it's a work in progress, and then you'll indicate those, because initially you said, and we agreed with you, that the report is a carbon copy. Because when I read it, now if it's a carbon copy, then there's no discrepancy. So let us rather do that. So, we'll hand over back to you with that caution that we are giving.
No, thanks, Chair. I'm well chastised.
No, not chastising. We just clearing process. There's no chastising.
Chair, let me state on record that the presentation by the SIU is exactly the same presentation of the SABC. And I confirm the accuracy in respect of the developments around both presentations. With regards to slide 12, on Sekela Xabiso, the SABC did not appeal the judgment, not because we disagree with the views that are held by esteemed colleagues in the SIU, but it was for financial reasons. That's the only reason we did not appeal. And if the appeal is successful, it's got the same benefits for the SABC as it will have for the SIU. On page 13, around Vision View Productions, which is a multi-purpose studio, I want to confirm on record that the SABC started using this studio from the 1st of April 20...
Just 1 second, Advocate. You said slide 13?
Yes.
Who's operating the... Can they be consistent with that, with what we are, the page is being referred to, please?
Yes.
All right, thank you.
So this is a multi-purpose studio, Studio 11. We have been utilizing the studio since the 1st of April. The SABC, prior to the legal dispute arising, had paid 34 million rands. It had not been utilizing the studio pending the SIU investigation as well as the legal process. And after the judgment that was delivered on the matter, we had sought to engage. You would have heard Advocate Tibi referring to the matter having been referred back to arbitration for what would have been a just and equitable order. Because arbitration itself involves finances, we had sought to have this matter resolved out of court. However, our efforts to settle this matter with the relevant service provider failed, and the SABC is also appealing that judgment on the basis that we need to get clarity around whether or not we need to pay, and if so, what will be a just amount to pay. If we go to page 16, 1/6 of the presentation, around economics, you would have seen from the report that in this matter, this is one of the matters where the SABC and the SIU are not the same applicants or the respondents. The SABC consciously decided not to oppose this matter because this transaction, in the view of the SABC, is an irregular transaction that ought to be set aside. So we agree with the course of action that has been taken by the SIU in this regard. On page 17, which really talks to the freezing or interdicting of pension interest, I want to point out, Chair, that there are a number of these matters that we are approaching the pension fund of the SABC. Initially, to try and not incur legal costs, we approached the pension fund to urge it to use its discretion to, without a court order, withhold the pension benefits that are payable to the member. Because at law, the pension fund has got an obligation when the pension interest becomes due and payable to a member to pay that money to the member, unless, of course, there is a court order. In certain instances, we do succeed in persuading the pension fund as an independent body with its own board to use its discretion. But in certain instances, we do get difficulties necessitating us going the court route to get interdicts in the process, incurring legal costs.
But
sorry,
just on that, Advocate, how sustainable, therefore, is this arrangement, if I may call it? Because it has no basis then, because it's discretionary. I think I think you may want to clarify us there, because the term discretion makes it optional. So if you can, but there's just 1 second, there's a hand. We'll come back to you, Advocate.
Chair, I'm just getting a sense that we are now writing his report for him. Because on every page that is referring us to, and if he's saying that he agrees on the SIU report, that is the same report. For instance, now what he's saying to us is that the SIU has freezed this particular person's pension fund. But now he's telling us that it might not be the case because of their policy. So now we're busy taking notes. We in fact writing his presentation here. So I would request that on every page that he has an issue or something to add on, they must quickly sit somewhere and do that check, because now we're referring to pages, but if he's saying it's the same thing, it's not the same, because what he's saying now is not what the SIU is saying. Instead, he's trying to explain to us that in an investigation where the SIU has been allowed to freeze this particular employee's pension fund, but now he's telling us that according to SABC policy and not what, it might not be the case because of this policy and that. We are going to end up being confused, because the matter on this page is telling us that a court has allowed the SIU to freeze this particular pension fund. So now here we are not going to be sitting and listening to the SABC telling us why it might not be and why it might be. We can't be writing his presentation, Chair. It's incorrect.
All right, let's wait. Let's hear these nuances that he's giving, because you see they're adding a context which we may not have had. So you see, because now we are duty bound to look at the whole arrangement of the freezing of pension funds and payouts, because I noted it here as well. When does it apply and when it doesn't? Now there's the term of discretion. I crave your indulgence for us to be patient, a teeny weeny bit longer, and hear it out. Let's hear these punctuations, and then you will have time to interview. But I hear the concern of the members. It's valid, because I still maintain the SABC should have had a presentation. That's the bottom line. But I plead with you, colleagues.
My clarity is that, is the SABC only interacting with this report for the first time? And didn't they have an opportunity to interact with SIU if there were areas of concern, so that they iron out all these issues before coming to us? Okay. Were that opportunity not presented to them? Because when you read on slide 4, it says the SIU can report that it has received very good cooperation from the SABC board and officials during the above investigations.
Okay.
What is coming out from SABC speaks contrary to what is contained on slide 4.
Okay, all right, okay. We are on track. Mr. Chair, let's hear from you.
Thank you, Chairperson, and thank you, honorable members. As the SABC, we engage with SIU on a frequent basis, so we are fully aligned. That's why when the chair asked that our presentation on the SIU matters is a copy of what the SABC or what the SIU has presented. So what we're trying to do was to try and give honorable members a comprehensive picture, because if you look at the SIU, they dealt with specific issues. There are other matters that we've dealt with, but maybe for the sake of progress, let's maybe engage in questions. If there are questions where there may be gaps or there may be need for clarity coming from the SABC, let's do it in that manner. But we are fully aligned with the SIU. There's no disagreement.
Okay.
Thank you.
That's fine. Colleagues, let's do it this way. Advocate Varara, how far do you have to go? How much more do you want to add? How many?
This was the last point, Chair.
All right, tie it down. Because I still maintain it. Let's hear the punctuations and the nuances. They will help. But I think it would have been proper for the SABC to have had these things put down, pen to paper, on the specific matters, because you see the frustration of members is now having to follow and make additions to a presentation that's not the SABC presentation. That is where the shortcoming has arisen. But I think that be that as it may, I'll look for another tie down the issues that you wanted to raise, and then I will come to you, colleagues. Okay, we good? Right. Progress.
Thank you, Chair. On the last issue, we, together with the SIU, obtained the interdict to stop the pension benefit being paid to Mr. Audrey Rapella. There is no contradiction there. All I'm saying is there are other similar cases, and the process, not necessarily the Audrey Rapella matter, but other instances where we need to get a similar arrangement. That is the process to follow. The discretion, Chair, you asked the question, it is a legal discretion. But they have a power in law, the Pension Fund, in terms of Section 34, capital D of the Pension Fund Act, to exercise judiciary. So in the event that they think that there are circumstances that entitle them to exercise that discretion, they do. In the event they hold a different view, they decline the request, and then we ought to go to court to go and obtain a court order. I must reiterate, the nuances that I'm highlighting, I could well have said them in respect of the same carbon copy presentation of the SABC. It's just that I thought, which proves to be an inconvenience, that dealing with the presentation that has already been tabled, it will be easy. It was not meant to create any conflict, because no conflict whatsoever exists. Thank you, Chair.
All right, thank you very much. The Chair.
Thank you, Chairperson. My suggestion would be that maybe let's allow you
You cited somebody else who must...
to avoid maybe getting into a similar kind of challenges. I'm proposing that we engage on questions. If there are specifics from an HR perspective, then Mr. Tekiso then can assist.
May I make this suggestion? Let us get HR to express themselves. I think let's allow that, because we might as well cover the grounds. We already knee deep in this kind of arrangement. Let's hear what HR has to say. And colleagues, I will beg your indulgence again that if it's punctuating anything, let's allow it. But the point has been made. There should have been a presentation. All right. HR?
Thank you, Chairperson. Good morning, honorable members. Good morning, Deputy Minister and colleagues. HR confirms the presentation from the SIU in terms of consequence management that has been taken. We also can confirm that where we have to, we've actually gone so far as to interdict retirement benefits of those employees. And Chairperson, in addition to the cases that the SIU have mentioned, which have been referred for disciplinary processes, we've actually done so in as far as those matters are concerned. And, you know,
in addition to those, there are about 9 matters, that we've proceeded with, where the employees have either resigned, retired, dismissed, given final written warnings or warnings. In some instances, we are not pleased with the outcome of the sanction based on the infringement.
1 second, I think let's not speak in generic terms.
Okay.
I think be specific now on those cases, particularly the ones that have arrived at a conclusion or in progress. I think in the meantime, pull out that presentation so that we speak in specific terms. So I'll give you the opportunity to formulate that so that we speak specifics, and then we'll take it forward. I think, Chair, that will be in order. Mr. CEO, then I'll come to you, colleagues.
Thank you, Chairperson. Good morning, honorable members. Sincere apologies for this confusion, but we did submit a presentation. The reason why the presentation is identical to what the colleagues from the SIU have presented is because we work very closely. You will see, for example, the details on the employees that are going through consequence management. Those need to be submitted to the SIU, and that information is derived from us. So we have submitted the required presentation, and I think what the colleagues were trying to do was just to re-emphasize and highlight some of the issues that may not have been covered. But it is exactly the same presentation because the information submitted is from the SABC on all of those cases. Thank you, Chairperson.
That's fine. On print out here, and I can't get my soft copy of this. On your slide on referrals to date, disciplinaries investigation has produced evidence to support 24 disciplinary referrals. I think those are the ones we are referring to HR. So can we get the breakdown of that? So I think what we should have done was that SABC should have spoken to their presentation and refer to the pages they wanted to expand on. I think when it started speaking to SIU, it raised the eyebrows. So on the 24, I think that's the one, unless there's more. So is HR ready one more time?
Can you project the presentation?
Ready. All right, let's get a briefing on the referred cases so that it completes the whole picture, and then we. Let's just allow the 4IR to run its course there. Come on. All right, there we go. All right, that's fine. All right, let's.
Okay.
All right. Can that also just be submitted to administration, and then we will take it from there? All right, over to you, HR.
Thank you, Chairperson. We now have the list of consequence management cases from the SABC. I'm going to take you line by line, Chairperson, honorable members, so as to give an indication as to how far we've come. You will note that on the first column we're indicating the name of the employee, and that's Alex Cupido. And the source of the investigation was the SIU, and the employee used to be with SABC Foundation. And Chair, you will note that the nature of offense, whilst on one hand it's about the outcome of the investigation of the SIU, we also have added, in most instances, the infringement coming from the SABC. So on this one, the offense was irregular awarding of bursaries, inclusive of gross misconduct as well as gross negligence. The employee was found guilty, the contract was terminated, and the matter is closed. Sorry, Chair. think I was in the middle of my, okay. So and I'll come back to Iris Cupido. So Ayanda Mkhize was an employee within the supply chain management process, and the source of the investigation was both forensic, our own internal forensic function, as well as SIU. And the infringement was irregular, improper, unlawful appointment and payment of Infonomics. And I'm sure, honorable members, you've already been exposed to Infonomics from Advocate Mutivi's presentation. The employee was dismissed on 17 October and referred a dispute of alleged unfair dismissal to the CCMA. And the matter is still at the CCMA. The second one, the chairperson and honorable members, was a gentleman called Zaki Rawoot. The source of the investigation was SIU. It was gross negligence in terms of the offense, dereliction of duties, gross dishonesty, and failure to act in the best interest of the organization. The employee resigned in the midst of a disciplinary inquiry. The next employee was Tanegan Lobu, and the source of investigation was both internal forensic as well as SIU. The infringement was irregular, improper, and unlawful appointment and payment of Infonomics. The employee was not found guilty. The company took the matter on review, and the employee proposed a settlement which the company has rejected. The matter therefore proceeds at the CCMA. The next employee, also referred to by Advocate Mutivi, is Mr. Simon Mulaudzi. He was, on the source of investigation, was the SIU as well as our own.
Connected?
You stay connected?
Yeah. litigation, whether on the civil, specifically on the civil side, that there would be listed such matters that have been pursued either by SIU or both by SIU and SABC, and the initiator at times being SIU and SIU being a joiner in some instances. Why primarily the authority itself, which is a primary institution, couldn't see it fit in some instances when such matters have been determined to move with such civil matters. And you'll find that in some instances, SIU pursue such matters as a lone soldier in a way. Does that give any strength into the factor that the board, in its own pursuance, in reality, of wanting to create a reputable image of SABC to begin to be involved in any other matter which has something to do with the image of the SABC as both a broadcaster and the institution which ought to show the side of reputation in terms of the public face. One would like to know in such instances to determine as to whether the primary driver on such litigation matters would be probably closer to what my colleague has indicated here, that the interest of SABC to be visible at all times, not to pick and choose on some instances where it would want to be involved and others not to be somewhat involved. Thank you, Chair.
Okay, thank you very much. Honorable Swartz. Honorable, I've got all of you on the list. Again, Almal Ope list.
He's laughing when you're calling my name, Chair. I don't know, he's got a problem here. The work next to me. Thank you, Chair. On page 14, I'd just like to know, Lona Vision and Aguma, for the TV licenses, they were doing the collection of TV licenses to that amount. I just want to understand from the SABC that ordinarily when you have such a situation where somebody is collecting on behalf of the SABC and this amount has been collected, how much does the SABC, in terms of percentage, get from companies that collect on your behalf TV licenses? And the amendments, did Lona Vision and Aguma object? As you are saying that if they had not objected to the amendments, then you were going to file by today, which is the 18th of September today, according to your report here. I just want to know, has the Lona Vision and Aguma objected to any of the amendments? And if they did not, are you filing today as per this? And then if the SABC can just highlight us and give us a sense that in a normal situation where the SABC is functioning properly and you have people, and also in my imaginary mind, I would imagine that this is where you are supposed to drive revenue collection out of TV licenses ordinarily as the SABC. People must pay for a TV license, and if somebody else is collecting, is there a policy or law that prevents you from collecting yourself, then using consultants that then collect such huge amounts of money? And what measures do you have in place in terms of the percentage that you get? My second question is to the chairperson of the board. If I heard you correctly, you said you have 180 cases which you are investigating internally.
Forensic investigations.
Yes,
reports.
internal forensic investigations, 180 cases. Did I hear you correctly?
Yeah, I'm sure we can just get a quick. Yeah, that's correct.
It's correct. No, I would like to get a sense, Chair, if you've got that huge number of cases, if at a stage you can please submit to the chairperson of Scopa in terms of what cases they are, what are we looking at, how severe are the cases, because if you are doing them on your own, and yet you have this working relationship that is very strong with the SIU, is it viable? Is it cost effective that you are handling 180 cases internally? Not minusing that you can do your own internal cases, of course, but I think 180 cases which are on internal forensic investigation for the SABC is a huge number for that matter. If we can get a breakdown, what type of cases are we looking at, how severe they are, and also in terms of time frames, what time frames have you put to the 180 cases? How old are they? How recent are they? Do you have all that in place in terms of where it is going to take us? Then on page 14, it speaks about, not on page 14, there was an issue of an upfront payment in the SIU's report of 20 million to one of the companies. It's very worrying that in an institution we can have upfront payments of 20 million without any work being done. How many people do sign in the SABC? If we can just get an example for such a huge payment to be approved, how many signatories does it take? Does it go to the board for approval?
To the slide 16.
16, yes.
Okay.
Slide 16, yes. Where we had the upfront payment of 20 million. So just for us to be comfortable, Chair, that there are, as the Chair said, that they are working very, very hard on fixing and implementing clean governance. That when you have upfront payments of 20 million being paid, and how many signatories does it take to approve an upfront payment of 20 million, and who does it go through? Is it just a one-man show? Who approves 20 million for an upfront, so that while you are doing your clean governance implementation, Chair, you take into note that there are these scary things of upfront 20 million payments, so that we understand, is there such a policy that allows upfront 20 million payments, so that we understand that if it's there or not, and because it's not in the notes, but during the presentation the advocate mentioned it. On our slide it's not there. I think it was on the slide that he was presenting on, so that we just get clarity there, what actually transpired. Thank you, Chair.
All right. Thank you very much. Honorable Liz, you've got the floor.
Mr. Chairman, it's encouraging to see the progress being made, and so thank you for that, so both to the SABC and the SIU. And so I'm just going to home in a little bit, having given the credit where it is due, and I think it is due. Now, just talking about the MOU with the NPA, why is it necessary to have special treatment for your cases? What is the problem with the NPA? Why is it necessary to go to the judges to get special case management? Is there a problem with the judicial system and you getting around it with special arrangements, and the rest of society is then having to live with the problem? So having said that you've made good progress, it's a concern of the methodology that may be being used. Because if there isn't a problem, why is it necessary to have a special MOU and to approach the various benches around the country and to have a dedicated prosecutor? So, but that doesn't detract from the work that's being done. But it does open a door about the problems we face in the country in the other respect. With regard to SABC, I'm not sure who's going to answer. The chair's leaving, but in terms of the disciplinary cases you've been dealing with, you've told us about a list of cases. Are there cases that you've lost? And what are the costs been involved, and why have you lost them? The Vision View studio, is it simply a case that the studio is great, but you're paying too much for it? Or am I misunderstanding it? I hear you using it, but you haven't paid for it in full. So what actually is the issue there? The tender might have been granted irregularly, but in the end, what are you trying to achieve? Are you trying to save some money, or do you want the studio taken away? You don't want it. The SABC, I think you're looking for 350 million bailout at the moment, is it? Something like that, a lot of money. And so the work that's been described this morning is very important in recovering losses and so on. But what about and I think one of my colleagues touched on this, the operations as they are now? The license fee collection, what is that costing? Is there a better way of doing it? But even more important is cutting costs. What actually are you doing to cut the costs of the operations and at the same time boost revenue other than TV licenses? Are you looking at increases in TV licenses? And what are you going to be offering? Is this simply because National Treasury and the Minister of Finance are saying, we're not going to bail you out, so you've got no option, you're going to have to increase TV licenses to not come back next year for an even bigger bailout? It you, Mr. Chairman.
All right, thank you.
Mr. Chairman, there is one other. It's a technical thing, and I'm not sure that perhaps SIU can answer it. When you freeze the pension, you eventually take that pension money. That's money that was never taxed in the hands of the individual. It's now not going to retirement annuity, it's going to pay for a TV studio or whatever else, I don't know, wherever the skullduggery took place. SARS surely is going to come after tax on that money.
Right. Honorable Machau.
Thank you very much, Chairperson, and good morning all. Let me add my voice by appreciating the report which was presented here by our SIU. It is for the first time for me to have a meeting direct with them. What I would like to know from them, when they are here, they are not only here for us to ask some questions, maybe to assist where there are problems that they are encountering as that entity. I would like to know, in terms of the capacity, looking at their core function. Sometimes I was once a mayor of a municipality whereby some of the investigations that are done by SIU just disappeared without any implementation. In which cases where issues that are recommended to municipalities are not implemented as such, or in any other, maybe cooperative, whatever. Secondly, how long does it take to put a matter back in the proclamation? Because that can delay a process. If the matter is not covered, but you want to proceed with it, how long does it take? The last one, I'm worried about SABC. How strong are your internal controls? Because CEO made mention that at least they have strong internal controls to avoid a recurrence, knowing exactly there are still rotten potatoes within the SABC. How are you going to curb it? How strong are your internal controls? Thank you very much, Chair.
Okay. Honorable Turks.
Thank you, Chair. Chair, I think we need to thank the SIU for this report, and also thank them for the cooperation they are giving Scopa and the working relationship they have with us. I'm saying this here because a week or 2 weeks ago when we had Steinhoff here and we had the Hawks and the NPA here, the Hawks was very eager that they want to pursue criminal charges and prosecute people. And it was so blatantly clear that the NPA had no appetite to prosecute. And you could see the politics in this whole thing. You just see the politics at play from the side of the NPA, that certain people must not be prosecuted. So we have serious problems with that kind of attitude as Scopa. Now, with our interaction with SIU, we are pursuing matters without fear or favor, and that's the kind of approach and cooperation we like. Having said that, my first question, I've just got 3 questions. My first question is on page 11. You know, I was on slide 11, we were listening to Mr. Claudi testifying at the Zondo Commission, and then he raised the issue that the SABC actually owes him more money because of the good work he's been doing that day. Now you're raising here at the bottom of this page, you say that on the 2nd of September 2019, Mr. Motsoneng filed a counterclaim. Is the counterclaim related to this extra monies that he said that he believes that the board owes him, SABC owes him? Is that the counterclaim that he has filed? That's the first one. Then the second one is on page 12, similar to the issue that was raised by Honorable Lee, as the cost. You are actually taking this application. You actually the review application was dismissed on the 14th of July, and you are going for leave. You have applied for leave to appeal. Now the amount involved, if I'm correct, the amount involved is 9 million rand. The security company. Now my concern is like you raised earlier on about getting Holocaust orders from the court. Perhaps you should look at when you lose a case in court and the amount that you are pursuing, it's not worth the effort to go after it. Then I don't think we should pursue these cases and appeal it and stuff like that, because you cannot throw good money at bad money, you know. For example, if it's 1 million or 2 million that you recover and then your legal fees is going over 1 million rand, why pursue it? The courts have ruled in favor of this person. Maybe it's just the ones that get away. Perhaps we should not waste too much of energy on those ones and on these appeals and stuff. Some of them we must perhaps just discard it after the courts have ruled in their favor. Yeah, maybe something you need to look at. Then the last issue is on page 14. Now, and I think I have to raise this issue, and I'll raise this issue in every committee, in every department that will come here to Scopa. You raised that you have submitted evidence to the SABC's attorneys. Now, usually when you write these reports, you just say attorneys, but then you name them, you put them in brackets, you said Werksman. Now, you see, when we say we clean up SABC and when we clean up State Department and government departments, we must clean everything and must clean it properly. Because every 5 years, political leadership in government will change. New people will come in. They'll have their preferences. They'll change you as a board member. They'll put the new president, put whoever wants to appoint there. So things change. People will put their preferences, and with that comes a host of problems where certain things again start happening, another group, new things are happening. The point I'm trying to make here is that when we look at, we're dealing with service providers of the SABC that has been appointed. I want to know from the SABC now, when you appoint attorneys as the SABC, do you have a panel of attorneys, or how do you go about appointing? Because they must also go through the procurement, through the supply chain processes. Attorneys must go through the same process. You can't just appoint them. The reason why I'm saying this here is because if you look at this Werksman, in this government of ours in South Africa, you go to transport, you go to central, Werksman is entrenched in government departments in this country. That's unbelievable. And it seems that they've captured government departments. And they also represent senior politicians in a personal capacity. So don't say we want to get rid of the one capture and there's another capture happening on the other side. We need to seriously look at this thing. One firm of attorneys can never be so entrenched in government departments like they have captured them. So this is something that we need to look at. So I wonder if you have a panel of attorneys, because I know that's what we usually encourage in municipalities, because I come from a municipal environment where we put a panel of attorneys out there, and then you use from the panel, where you don't have this thing that one company gets used over and over. Because that's how it all starts. So it starts with that money, you bring somebody else in, and that's how it starts. So we must say, when we clean up, we must do a proper cleanup. So I just want you to respond to the issue about the panel of attorneys, how do you appoint attorneys? Thank you.
All right. Thank you very much, colleagues. I think the questions have been very comprehensive. So what we will do is we'll start with the SIU, and then the SABC will answer on its components. So you will do a distribution of delegation of responsibilities on the questions cited. So this will finish, and then the SABC can come in on all the issues that it needs to raise. I just want to speak on the issue of Sekela Xabiso, because I think beyond the fact that the tender is questionable, the fundamental issue was why they were brought in to begin with. Because there was a duplication of work. It was work that had already been done, and then they were coming in now to, if I'm not mistaken, to ascertain irregular and fully expected work which was already done. So that never sat well with even with Scopa in the Fifth Parliament. The reason, put aside the, just why they were there to begin with, on its own was an issue. So if you could speak to that. I will come back on the issues of HR and the disciplinary cases, because I think we would want a schedule of all the matters that you have dealt with. Because the other thing is, the operative word for this committee is public accounts. So every time we're going to be meeting with an entity, it triggers traffic of information about the particular entity that we'll be dealing with. And there are serious issues insofar as HR is concerned and the processing of work. So we'd want the issues you've dealt with, because the issue of the 180 forensic investigations that has been cited, what the outcomes and implementation thereof, what becomes of the findings of those reports, because we've spoken about only 24 referrals here, and I was counting the schedule presented by HR went up to 14 individuals. So where are the individuals or persons arising out of the 180 forensic? What action is being taken in that space? And of course, the cost factors involved in all of these matters. I think SIU, we're quite happy with the work so far that you are doing in this space of the SABC, as we unravel the web of state capture. Because SABC was at the receiving end, internally and externally, of the well laid out program, to the extent to which the perception is not lost that SABC became a state broadcaster, not a public broadcaster. So we have to unravel that web so that we can re-entrench it to inspire the public confidence for whoever is seeing the SABC. Because if we don't do that, then these things persist. But to do that, we also need to drill into the governance structures and modalities at the SABC. Because we may be dealing with the political elements outside But the extent to which state capture prevailed was that it was entrenched in institutions. And so it's important that we give due attention to that. I want to reiterate the issue of the bailout and the request thereof, and the issue of collections of TV licenses. You know, I don't have a TV, but I'm paying a TV license. And tell me more, I'm trying to get it stopped, which I don't have one. So, but fair enough, I'm paying, all right, good, maybe the SABC may need my contribution, I'm not sure how far it goes. But what it calls into question is the integrity of the register and the role of people who should be paying TV licenses and the process therein. And so I think the issue about the consultants and the service providers who are doing the work on behalf of the SABC to collect these TV licenses is important, because you will find that people who should be paying are not paying, and so on. And so you're bleeding revenue there. I mean, every rand and cent counts when it comes to the SABC, given your problems. And so that particular area is not. So I'm not raising this about me. I'm not bothered. I've given up on my fight with it. It's fine. So it's not. I don't want it responded to me. What I'm raising is the issue of the management of this particular collection, and how it is actually, proceeding. So I think let's get responses to that. I'm glad that the Deputy Minister is here, and we will give her an opportunity at the end if there are issues that she would want to raise. And of course, there are issues in the public domain as well, which we'll raise with you, that we just want clarity on, insofar as a board member is concerned and the university, just to clear the air insofar as and what action the SABC is taking to track those particular matters. So I think your presence in that regard helps. Finally, SABC, your issue of freelancers, if you can speak to that and the modalities of the management of that particular area and the costs involved. Because in certain instances you are finding that people are in the office bound rather, studio bound, newsroom bound, and not being dispatched, and a freelancer somewhere. And there's a proliferation of these freelancers. I raise this in the context of the question of cost-cutting measures, and so on. Then there's the funny issue, which I think even in other platforms we have raised. You send a news crew all the way to Destination X to cover a story, and it never sees the light of day on the screens. The costs involved in just transporting people, the movement. So even those things. So the portfolio issue, on so far as freelancers is concerned, whether an audit has been done, maybe I think let me put it that way, of who's who in the zoo doing what, where, and why, and the processes which were followed to get these people into the establishment for SABC. I think it's opportune that you clear these matters for us. And then finally, since you are here, Chairman, rugby. Are we going to be getting the World Cup or not? And well, that's a different question altogether. But if you can just take us into confidence about those things so that you can explain them and they are understood. If there's cost factors which are beyond the SABC, let's deal with that so that we push back on the so-called narratives of blackouts. But I would like to see the rugby. All right, so let's hand over to the SIU, and then the SABC will come in as well and cover its issues. I think, colleagues, we are doing well for time. We would really want to tie down on everything by no later than 12:30. Yeah, all right. Advocate.
Thank you, Honorable Chair, honorable members, and and to the Deputy Minister. The question around the special tribunal, under what legislation is it been established and what is its jurisdiction? It is established under the Special Investigating Units and Special Tribunals Act, which is the act that saw the creation of this special investigating unit. That tribunal was established some time back, and we can really check when it was, but it was in the 2000s. But it ceased to operate at some point. And this was as a result of some of the legal challenges that were made at the time around its jurisdiction, and some of the technicalities that the legal representatives brought. And it really ceased to operate up to now, I think, well over 10 years, 15 years or so. It was around 2001 when it ceased to operate because of those legal challenges. So when we embarked on the new strategy, which I said really is not materially different from the initial strategy, which was to investigate and make sure that we recover and recover speedily. We then realized that with the case load that we have on our books, which has got the value quantified at about 14.7 billion. If we are to recover as speedily as possible, or as speedily as is legally possible, and looking at the pace at which the cases are going, and I'll come to the honorable member's question around why do we approach the judges. We realized that firstly the cases get delayed in the sense that you would have seen one of the matters, the trial date is only given in a year's time. We sat down and said, why is it that we cannot use this legal avenue that's provided by the law to speed up these matters? And some of the lawyers around the table have said there is a purpose for which this legislation provided for this tribunal. And the immediate view that we had was that it can enable us to speed up the process of recovery. So, because it was already proclaimed at the time, as what we are doing at the moment is we are just re-establishing it. And obviously we went through the process. It went to the Minister of Justice, and then it went to the President. In February this year, the President issued a proclamation that seeks to really re-establish this tribunal and allocated the judges around the country in all the 9 provinces. So, yes, it's issued under our legislation. What is its jurisdiction? It's got the jurisdiction similar to a High Court. So it can make any order that the High Court can make. That's provided for in the legislation. However, there's rules and regulations that need to be published. Regulations are published by the minister, and the rules are published by the Special Tribunal President. Those would then seek to regulate some of the processes of the tribunal and so on. So that's the rationale of re-establishing the tribunal, and we're hoping that it would achieve its purpose as was envisaged in the legislation. We take the comment by the honorable member on board that we should take the public on board more around the work that we do as SIU, and we have incorporated that part in our communication strategy. we have in our new strategy a focus on the prevention part of the fight against corruption. And the prevention would entail aspects like raising awareness and ensuring that we have a clear prevention program. And that prevention program, amongst others, is also driven under the anti-corruption task team auspices, but it's driven by SIU. So part of what we are doing, Chair and Honorable Members, is to ensure that this awareness program takes into account, in other jurisdictions, we've seen that some of our peers in Africa and in some of the Asian countries, they even have a program that goes to the schools. So this is part of what we will do going forward in terms of ensuring that we target the public, more communication of our work, our outputs, but also as part of the overall prevention program. There are aspects of what we need to do. The Honourable Member also referred to the establishment of the Tribunal. So we are hoping that once the rules and the regulations are finalized and published, we should see that Tribunal functioning. The lives of the executives, I think this would probably, SABC would respond to that, but I can also comment that we take the protection of anyone that we have to deal with, we take it very serious. We've had instances, and not at SABC, where witnesses have come up and said we feel threatened and so on, and we've taken on board the witness protection program, which is run by the NPA, and ensured that those witnesses are protected. So in any instances, we are ready to support on ensuring that there's security. How many appointments did we not find evidence? I think this is the matter really that occupied the board and the SABC for a while during the presentation. I should just say here that in one of the interactions we had with the SABC, this matter came up, and that we presented that to date, the evidence that we have seen does not support the allegations that there were irregular appointments. But yes, the SABC did raise it with us, that we've got a different view. And the teams, and I was informed now that the meeting, yes, did take place, and SABC has presented to us further documentation and information. If we are persuaded otherwise, we will make an appropriate finding. So this is an ongoing engagement, which between the two teams.
I will also ask Edward Kvanara to make a comment when the SABC comes, because he was touching on the matter.
Yeah. Yes. Okay. Slide 19. All the other 10 cases. All the other 10 cases that have been referred to NPA to date. As we said, why the NPA has provided us with an assurance that they are receiving attention. They've even provided a prosecutor who's dealing with those matters. But yes, as we speak today, only one matter has been to court on the prosecution side. So we are in engagement with the prosecutor, and I'll come back again to the question raised: why do we have an MOU with the prosecution? There's particular reasons for that. I will revert to that point. The question about the review of the contract, Sigela Claviso, the basis for the appeal. The basis for the appeal is that we are satisfied. Well, we have satisfied ourselves based on the legal body of research and the legal view and the jurisdiction that we have gone through, that the Honorable Judge may have misdirected herself here. So we are wanting to ensure that this legal aspect that we seek to get clarity on and appeal against is set even at the highest level of the court, so that it doesn't create the precedents that will impede us in future. The legal position of any aspect of our work is very critical, such that we don't meet with that impediment going forward. If the honourable member wants the exact nature of the course of action, we can provide that. But in this regard, yes, the SABC did indicate that it is also will be in their interest if the matter is ruled in favor of SIU in this regard. And then I'll come back to the issue around the economic nature of litigation. You know, we shouldn't chase an amount where we're going to end up paying more and recovering less or nothing. The deadlines of the 16th and the 18th. Okay.
I think that I also wanted to get clarity in terms of its dismissal. Was it on technical basis or on legal basis? Hence, you're reviewing. So you only spoke about the appeal side. If you get my question. Okay, cool.
I'm going to just hand over now to probably the Chief Legal Counsel, who can expand on that, and also comment on the deadlines of the 16th of September and the 18th of September, and whether we have filed those documentation, because it's important to get that view. Thank you.
All right, can we get that executive summary?
Good morning, Chair, Honourable Members and Deputy Minister. I'm going to deal with the slides, the question dealing with slides 11, 14 and 17. I'll do it in chronological order. Slide 11 refers to the counterclaim. That counterclaim indeed incorporates a claim for additional success fee. The quantum is approximately 16 million. We will assess and appropriately respond thereto. As you know, the claim, the principal claim, is in any event that he should not have been entitled to any amount. If we move to slide...
Just on that 1 second. SABC, can I request that, because it seems as if the Hlaudi Motsoneng
Oh, there we go. There we go. There we go. Okay, Kesha. All right. Now you're happy? Okay. All right, let me set it up perfectly. Yeah? I was ready to.
I can hear you, yes. 1, 2, 3, 4, 5.